Mr. Toffey.
Before the short adjournment, I was dealing with various points which the appellants raise in relation to the Court of Appeal judgment on ground 4. If I could just finish that off, please. My learned friend says that the Court of Appeal appears to have reasoned no order was required because PFF was insolvent and insolvent liquidation was inevitable. But our submission is that that misunderstands what the Court of Appeal was saying in paragraph 111 at page 77, because that paragraph merely sets out the background for the reasoning for the exercise of the discretion. The reasons themselves and the basis of the decision are set out in paragraph 112. All the Court of Appeal was pointing out in paragraph 111 was that the repayments did not put PFF into an insolvent position. It was massively insolvent in any event. And that was plainly a circumstance that it was entitled to take into account. And we say that the suggestion that the Court of Appeal didn't take account of the fact that if no repayment had been made, there wouldn't have been an extra £13 million for PFF's creditors can't hold water, because that was the whole purpose of the Insolvency Act claim, to claw back $13 million for PFF's creditors. And one sees from paragraphs 100 to 103, pages 72 to 73 of the judgment, that the Court of Appeal had that plainly in mind. Now, my learned friend complains that the Court of Appeal didn't give any weight to the reputational benefit which Ms. Chen obtained. Now, our submission is that the Court of Appeal was fully entitled to regard the reputational benefit as being minuscule and having no weight. If the appellants wanted the court to quantify the benefit received by Ms. Chen, it was up to them to plead it and to provide some evidence to do so, and they didn't. And there's no correlation between the payments to Zanato on the one hand and the quantum of the reputational benefits to Ms. Chen on the other. And so it's not possible simply to say, well, because Zanato received $13 million, therefore Ms. Chen received a corresponding benefit of $13 million. And indeed, that case wasn't put forward to the Court of Appeal. It wasn't in the pleadings, the witness statement, transcript, the written submissions. There was no attempt to quantify the reputational benefit at $13 million or indeed any other amount. And so the Court of Appeal did the best it could in all the circumstances. It looked at the amounts which were owed by PFF, which were, the Court of Appeal thought, $187 million, and the amount repaid to Zanato, which was $13 million. And indeed, $13 million is less than 7% of $187 million. And we submit the Court of Appeal is fully entitled to hold, therefore, that the amount repaid to Zanato was minuscule and that no weight could be attached to it. Indeed, the appellant's written case footnote 40 at page 2231 asserts the total admitted to proof is $404 million, and $13 million is a much smaller proportion of that amount. But we say the Court of Appeal's conclusion must be the correct one, because after liquidation of PFF, third parties wouldn't say, oh, look, Ms. Chen has repaid $13 million. They would say, look, a company ultimately owned by Ms. Chen has gone into liquidation with debts of $187 million. So the repayments to Zanato are wholly overshadowed by the remaining debts. The appellants also say that the payment wasn't minuscule because it was $30 million, or it was 100% of the sum owing to Zanato. But those submissions wholly ignore the bigger picture of PFF's overall indebtedness, which had to be taken into account, and which the Court of Appeal did take into account. There is a suggestion that because, by the appellants, because Eddie confirmed the repayments were made for reasons of Ms. Chen's reputation, that shows there was a real reputational benefit for her. Now, Mr. Byers admitted in cross-examination, and it's at page 1194, line 25 to 1195, line 11, that this alleged confirmation from Eddie had only been inferred by him. In any case, Eddie denies that he said it. I'll just give you the references. It's his first witness statement at pages 964 to 965, paragraphs 98 to 102. His third witness statement, which is page 1032 to 1033, paragraphs 10 to 14, and the trial transcript at page 1520, lines 6 to 24. But even if he did say it, again, there's no evidence adduced by the liquidators as to the quantification of this real reputational benefit. Indeed, Eddie's not an expert, and how could a layman's comment as to the reason for payment amount to evidence of the value of the benefit? But the real fallacy in the appellant's argument is that the Court of Appeal did proceed, though not through their own fault without evidence, on the basis that there was a reputational benefit to Miss Chen. They regarded it, as they were entitled to do, as minuscule, but they did take it into account. So we say that criticism goes nowhere. They also say the Court of Appeal should have concluded the judge made no finding on reputational benefit and remitted it to the judge. But that point goes nowhere, given there was no pleading that Miss Chen received a reputational benefit, and there was no evidence led as to it. And so the Court of Appeal was in a position to make its findings and exercise its discretion on the basis of the evidence before it as to the quantum of the repayments and the overall indebtedness. It's also said the Court of Appeal wrongly held the fact that Ms. Chen knew about the payments shouldn't carry much weight. As we've submitted before, whether or not she knew of the repayments isn't relevant to a restitutionary order as opposed to a compensatory order. But in any event, the Court of Appeal was plainly aware of the judge's finding that she knew and didn't object, and they took it into account. We see that from paragraph 112, page 77 of the bundle. The view they took was it was just one of the factors which felt to be considered in the exercise of the court's discretion, and all the circumstances wouldn't carry much weight. And we say that that's the view they were entitled to come to in the exercise of their discretion. That's all I would like to say about ground 4. I would like to move on now, please, and I'd like to address next ground 3, that the Court of Appeal should have found that Ms. Chen caused and or procured repayment of the Zenato loan. I want to start with that. It concerns the finding of fact that the judge made that Ms. Chen didn't cause or procure the repayments to Zenato. And the reason I want to start with this is this: if the concurrent finding of pure fact that Ms. Chen didn't cause or procure the repayments to Zenato isn't interfered with, the liquidator's claim that she breached fiduciary duties would necessarily fail. And we submit, as indeed we submitted to Justice Bannister, and you'll see that at page 198, paragraph 8, we say that the appellant's case rests entirely on speculation. Mr. Byers for the liquidators accepted that there was no direct evidence that Ms. Chen caused or procured the repayments. That's his cross-examination, page 1185, line 24 to 1186, line 12. And his witness statement, paragraph 79, as page 879, is where we find that claim that Eddie confirmed in the interview that Ms. Chen instructed the payment of loans to friends' companies during the relevant period. But in cross-examination, as I mentioned before, page 1194, line 25 to 1195, line 11, Mr. Byers accepted he only inferred that. Indeed, the only piece of evidence the liquidators relied on was the note, and I will come back to that in a few minutes if I may. The primary matter I want to address is this question of whether or not Ms. Chen caused or procured the repayment of the Zenato loan. And the committee will have seen that we have, in our written case, at paragraph 22 on page 2252 to 26 at 2254 drawn attention to the fact that although the appellants use the word arranged, the pleading itself is caused and procured. And since the pleaded allegation has been caused and procured, that phrase has been the focus of the parties and the courts throughout this case. Now, there's some attempt to say that because Miss Chen knew, and a judge found that she probably knew about it and did not object, that therefore that is equivalent to causing and procuring. And just want to just expand on what we say about that, if I may, because we submit that knowing and not objecting, it isn't relevant on its own where there's no duty. Knowing, not objecting may not be relevant depending on the circumstances if there's a duty. It's knowing, not objecting, and duty and circumstances suggesting a culpability that there is misfeasance. As things stand, we have no pleading of knowing and not objecting, and therefore that issue is not litigated. And we have a finding of no duty and a finding of circumstances suggesting a lack of wrongdoing. And the finding of duty and circumstances suggesting culpability are both fact sensitive, and our position, as the committee will know, is that both courts reviewed the facts and they found no duty and no wrongdoing. But we say it's not possible to convert the judge's finding of knowing and not objecting into causing and procuring. Knowing and not objecting isn't the same as causing and or procuring. Knowing, not objecting is passive, whereas causing and procuring is active. But crucially,
I think Lord Leggett has a question. Yes, Lord Leggett.
You prefaced this part of your submissions by saying no and didn't object isn't enough where there's no duty. But I know you haven't reached it yet, but let's assume for these purposes that there was a fiduciary duty. Now, obviously, there has to be a causal link between a breach of fiduciary duty and a loss, otherwise there's no liability for compensation.
Yes, my Lord.
You know that a payment's being made, you owe a fiduciary duty to prevent it being made, and you do nothing to prevent it being made, then haven't you simply, have you not then caused payment in the relevant legal sense?
Well, it rather comes down to that discussion between Mr. Smith and Lord Bricks this morning as to what is the content of the duty. And I will come back to it if I may, but what we'd say is that on the basis of the findings of fact in this case, no duty would arise. But crucially in this case, that there is no finding by the learned judge as to when Miss Chen knew. He doesn't say whether she knew about it before or after the payment was made. And if she only found out after the payments were made and didn't object then, she couldn't in any event be said to have caused or procured via knowing and not objecting. And so an essential factual element of a case of, as it were, converting knowledge and not objecting into causing and procuring is missing from the learned judge's findings. And we say that the precise formulation is essential because causing a payment doesn't necessarily amount to a misfeasance. And this is a point which was actually mentioned by the learned deputy judge in Oxford at paragraph 93. And if one goes to page 2970 of the bundle, at letter H, his lordship refers to Brian Pearson, where Hazel Williamson QCC, who's a deputy, rightly, in my judgment, rejected a submission based on West Mercia and Dodd, that it followed that the causing of a preference in itself amounted to misfeasance, and pointed out that in West Mercia involved a specific finding of a conscious application of the company's funds for the known purpose of preferring the debtor's own interests or those of their associates. Claim for misfeasance spend on positive proof, and that a significant additional burden is placed on a liquidator where a preference has been established by application of the relevant burden of proof under section 2396. So, because the payment doesn't necessarily amount to misfeasance, it is important that the allegation is put in a precise way so that the respondent can answer it. Now, in this case, the liquidators never amended their amended statement of claim. At the hearing in January 2015, the judge said the liquidator's case would collapse if they didn't prove causing and procuring. And I did have the reference to that. I'm afraid I've lost it, but I'll ask my learned junior to find it. But at the beginning of the trial, we objected to the fact that their submissions referred to causing and permitting rather than causing and procuring. And you see that at page 1171 and 1174 at lines 7 to 11, where the judge says that causing and permitting and procuring and permitting are different concepts. And again, the liquidators didn't amend, notwithstanding being put on clear notice of our objection. Plainly, they must have realised the difference, and yet despite everything, they chose to continue and not seek leave to amend. And the reference I had in mind, which I couldn't find, is page 1111 at lines 11 to 13. And had knowledge, not objection, been pleaded as a basis of causing and or procuring, then Ms. Chen would have been able to plead to it specifically, so the court would have had an issue on which to rule. Ms. Chen's evidence would have been able to address the issue specifically, but we have neither pleading nor evidence on this issue. Legal submissions would have been made in relation to liability arising out of knowledge and not objecting in various circumstances, but as things stand, none of those things took place. Because
were those points made at the trial, and what happened? Because that's the time to make these points.
No, they weren't, m'lady.
On behalf of Mrs. Miss Chen.
No, but the point was that we had said that it has to be causing and or procuring. So we weren't addressing knowledge. What Ms. Chen's case was, as the judge records, that she didn't know about these payments and that they were made without her knowledge. So we were only addressing causing and or procuring, where there's no reason for us to address knowledge and not objecting. But what I'm saying is that the only allegation was causing and or procuring. There was no suggestion from the other side at the trial that there was some broader concept, because they had tried to introduce that broader concept in their opening submissions, but we had objected very strongly at the beginning of the hearing to them doing that. So
did anyone get up and say to the judge after judgment was delivered, I'm sorry, that is a very imprecise finding and you need to clarify at what point in time she knew and did not object?
No.
That's of course open to you.
Well, my lady, the judgment was in our favour, and so it wasn't for us at that point to consider any question of clarification, because at that time the judge had ruled in paragraph 29, I think it was, that he said she knew and didn't object, probably knew and didn't object, but she didn't cause and or procure, which he said was completely different. So what he was dealing with was the pleaded case. So having decided in our favour on the pleaded case, there could have been no reason for us to go back to the court and say, well, Judge, you come out with this particular comment which doesn't address a pleaded issue. Please, can you clarify it? Lady, it would have taken enormous foresight on our part to know that in three years later, that this argument was going to be raised before the committee. We had no reason to go back to the judge at that time.
Well, there we are. But the
I'm sorry, my lady, your audio is cut out.
thank you. In the context in which
I'm sorry, my lady, you've cut out again.
I'm sorry, Lady Arden, we can't hear you. Can you unmute? I'm not sure what's going wrong there.
Can I make a suggestion? Maybe I could. Maybe the bandwidth isn't sufficient to incorporate both sound and video at the moment. If she knocks the video off, maybe we can hear her.
Thank you very much, Mr. Smith. I don't know whether you had that, Lady Arden. Yeah, we still can't hear you, I'm afraid.
later.
Oh, here we've just come on again. Try again. I'm sorry, you've just gone off again. Oh dear.
We'll leave it.
Yeah.
Thank you.
Thank you. Let's proceed, Mr. Joffe, then, for the moment.
Thank you, Lord. I just want to finish off by saying causing or procuring payments is to be made improperly is a serious allegation. It is an allegation which should be precisely and properly pleaded, so the respondent knows what case is made against him. And as I said, the whole case was pleaded and fought on causing and or procuring, not knowledge or and not objecting. And we submit it's not proper or fair that on a final appeal the case should be subtly changed against Ms. Chen in this way, because she had no chance to really defend herself against it. My learned friend raised a point on the amended statement of claim at page 177 at 13. So sorry. Beg your pardon. It's I've got the wrong.
If you can tell us what you want to refer to.
The amended statement of claim, paragraph 13.1, my lord.
113 starting.
Starts at 113. I think it's 117 rather than 177. I do apologise.
That's all right. Right. Yes.
My learned friend raises paragraph 13.1 and he tries to rely on the fact that it says Ms. Chen was therefore responsible for authorising and causing or procuring. Now, I say straight away that's a new point. It's never been raised before. It's never been said that by setting up a structure that Ms. Chen was responsible for causing all subsequent payments. And it wasn't put to her that she caused and or procured by simply delegating to other staff. And indeed, the attempt to expand 13.1 in our submission simply doesn't work, because if you look at paragraph 34 on page 124, you've got a pleading there that says, as pleaded in paragraph 9 above, in absence of demand from Zanato, Ms. Chen caused and or procured the payment of Zanato loan. It doesn't say she authorised and caused and or procured. And if you go back to paragraph 9, which is at 115, we see exactly the same pleading. And paragraph 9.2, breach of those fiduciary duties in a time when PFF was insolvent, fact which she was aware or ought to have been aware, purported repayment of a loan, she caused and or procured PFF to make the following payments. So we submit that the plain meaning of the amended statement of claim is set out in those two paragraphs, 9 and 34, which are pleading the allegation. It was undisputed at trial that the transactions were carried out electronically by members of the staff, probably PSG, but that wasn't, I think, identified. There was no evidence that Ms. Chen made any specific delegation. She said that she told members of staff that they should make these payments, and indeed she denied it in cross-examination. And what we say is that in the absence of any evidence that she specifically told staff to make these payments, that it's simply not possible to reach a conclusion that she caused or procured the payments to be made. And the suggestion my learned friend now seeks to make is, oh, well, since she knew and didn't object to it, that's equivalent to causing. We say simply to completely twist the concept that is advanced in the amended statement of claim. There's nothing, you would not get a clue by reading the amended statement of claim that that was the case which was now being put forward. The evidence on this is...
Well, if she knew and did not object to these transactions, can it be said that she authorised them?
No, my lord, I would say that she may have been an ex post facto ratification of it, but causing or procuring is not the same as authorising. It's certainly not the same as what your lordship has described.
The pleading in paragraph 13.1 is that she was therefore responsible for authorising and causing and or procuring all payments. So you are facing the allegation that she authorised as well as caused and procured the payments.
Well, the Lord said that she was responsible for authorising and causing or procuring all payments. But when you actually look at what it is alleged, she is alleged to have done, which is paragraphs 9 and 34, they simply say caused and or procured. And indeed, my lord, put in this way, responsible for authorising and causing and or procuring all payments, there would have to be some evidence that she had authorised the payments themselves. And the evidence was that she hadn't authorised these individual payments. What she'd she set up a structure, and that structure was then operated by staff. All the payments were operated electronically. So she plainly thought that the staff were the sort of people who were perfectly responsible and could be trusted to carry out these payments. And indeed, Eddie Chen's evidence was that the staff carried out the payments. So apart from setting up the original structure, where she presumably must have given the log-on details to members of staff, she had no involvement, and certainly no involvement with the Zanato repayments. We know how those came about because Eddie Chen gave evidence that he recommended them to Mr. Gan. Mr. Gan approved them, and then they were carried out by individual members of the staff. So there was no involvement of Ms. Chen in that process at all. And so the conclusion which was reached by the learned judge and indeed by the Court of Appeal on this point was unimpeachable in our submission.
Well, is the case made on behalf of Ms. Chen that he was wholly ignorant of these payments?
Yes, my lord, that was her evidence, that her evidence was that she didn't know about them prior to the proceedings, and it's recorded in the judgment. And the judge said that he thought that the probability was that she knew and didn't object. And he then went on immediately to say, but that doesn't mean to say that she caused and or procured them. She didn't. And he expressly found that, my lord. So he clearly drew that distinction, which we are also seeking to draw between, on the one hand, knowledge and not objecting, and secondly, causing and or procuring. And as I mentioned before, there's a timing issue there, because if she only knew about them afterwards and didn't object, that's a wholly different matter to knowing in advance. And absent the judge finding that she knew about those payments prior to them being made, and he didn't make that finding, in my submission, this suggestion that knowing and not objecting is equivalent to causing and or procuring, that simply can go nowhere.
Yeah.
I'm sorry, Mark.
It's just that you're working perfectly understandable reasons from the end argument to what certainly for my part I consider to be the principal argument, and that is the currency of her directorship. And this will obviously bear on this question of authorising or causing or procuring. In any event, do proceed, Mr. Joffe.
Thank you, my lord. The main evidence on which the liquidators sought to rely on what was the note, and I'd like, if I may, just to deal with that. The appellants say that the note was accurate and supported by the evidence of the liquidators. What we would submit is this: firstly, the judge correctly recognised at trial judgment paragraph 23 on page 27 that the note was only a summary, not a verbatim account. We would submit a summary is necessarily less reliable and of less weight than a verbatim note. And the judge was entitled to take into account that it was just a summary. Secondly, he also correctly recognised that it didn't set out the questions and the answers verbatim, so it was impossible to know what had been suggested and what the exact responses were. And that was something which affected its reliability and weight, and the judge was entitled to take that into consideration. Now, my learned friend says, oh, well, attendance notes are always summaries. That may be true, but the point is that where you have a synthesis of question and answer, which is produced by one party and is not checked or agreed to by the other party, if you don't have evidence as to what the questions were and the answers were, then necessarily you don't know who said what. And the judge was perfectly entitled to take into account the fact that this was an attendance note in assessing its reliability and weight. And the judge was also correct to take into account when assessing the probative value of the note that Eddie Chen had never been given the opportunity to confirm his answers, despite his requests to review the note. And Eddie never confirmed its contents. Indeed, he refuted the answers in his evidence. If you look at Eddie's first witness statement, paragraphs 98 to 102 at page 964, 965, his fourth witness statement at paragraphs 5 to 14 at pages 1028 to 1033, and his cross-examination transcript at page 1517, lines 3 to 8, and 1521, lines 13 to 19. It's quite clear that he refutes the answers. Indeed, I would invite the committee to look at the whole of Eddie's cross-examination on the note. It's page 1510, line 15 to 1526, line 9. Sorry, my lord.
Yes.
At the least, isn't it, Mr. Joffe, pretty astonishing transition from a note which records him as saying he didn't know about the Donato payment and it was arranged by PSG, to evidence in which he said he actually organised the payment and did so with the approval of the mysterious Mr. Gann.
Well, Lord, yes. It's something which the point that was raised before the Court of Appeal. The Court of Appeal took the view, well, the trial judge was entitled to decide whether or not he accepted Mr. Eddie's evidence. And I'm sorry, my Lord, I'm reminded that in fact, that what Eddie says is that there are actually two different things here. That what Eddie said he didn't know about was was what he called payment, i.e. the original loan, that he knew nothing about that. But what he did know about was the repayment of the loan, because that was what he organised. So it's not that he went from saying he knew nothing about repaying the loan to saying he organised it, but he was saying he knew nothing about the original loan, and he organised the repayment of the loan.
Well, that's fairly extraordinary explanation when it refers to the Donato payments in one paragraph as the repayment, meaning the repayments, obviously. And then when he talks about the funding and the payment in the next paragraph, he says payment actually means receipt, as I understand his evidence. I mean, you can say that black is white, but there is a limit to what surely the judge can be enough to accept.
Can I just take your lordship to the transcript?
No, I don't have it. It's keeping notes using Eddie's transcript, cross-examination.
That's it.
Yeah.
We go to 1517. And lines 3 to 8. And he says that the meeting notes didn't confirm the man. It has various mistakes, missing a lot of information. And then 1521. He says, I didn't say it was made up, I just this meeting notes full of mistakes and missing a lot of information. It's not a verbatim transcript. So any speculation on their understanding what I'm saying, I asked twice to confirm the meeting notes as a professional, as GT company, I never get a response. And what he says in his fourth witness statement is, well, I was talking about two different things. I was talking about the fact of the original loan. That was something that was arranged by the parent company. That was something that I knew nothing about. And I was talking about the repayment, and it was the repayment that I was responsible for organising. So, my Lord, I don't actually see the difficulty your lordship's facing.
Yes, Lord Liggett. You need to unmute, I'm afraid.
Did he give any explanation of what he claims to have said about the repayment? Because obviously the liquidators were very interested in this repayment of the loan. That's one of the main reasons they were there. So it would be extraordinary if they hadn't recorded what he said, but did he have a version of what he told them? Was it that did he say, I told them that I gave the instructions and Mr. Gann approved them, but they just didn't note that? Was that his evidence?
I can't recall it precisely. I'd have to look it up. Rather than holding the committee up, can I perhaps ask my learned junior to find the references in the transcript while I carry on, and I'll give them to you later?
Thank you.
The liquidators also, the appellants also complain about the judge's finding that all the court had was the note, because they say their oral evidence confirmed it was an accurate summary of what he said at the meeting. It is clear that the liquidators had no independent recollection of the meeting. And you see that from a number of things, and I've already drawn attention to some of them, but just drawing them together, Mr. Byers in his first witness statement, paragraph 79 on page 879, said that Eddie confirmed that Ms. Chen instructed payment, but in his cross-examination he said it was inferences, and I've given you line 6 on page 1194 to line 11 on page 1195. And Mr. Byers didn't check the notes of the meeting. That's his cross-examination transcript, page 1198, line 21 to line 1199, line 25. Mr. Byers said he couldn't remember everything, cross-examination, page 1199, line 22 to 25, and page 1200, lines 23 to 25. Mr. Byers said he couldn't remember independently without referring to the note. He only remembered the general sense and direction that the meeting took. That's the cross-examination at page 1200, line 17 to 1201, line 5, 1203, line 17 to 1204, line 1. And in fact, the note was prepared not by Mr. Byers or Mr. Charters, but a lady called Miss Welch, an employee. That's Mr. Charters' cross-examination at page 1234, line 14 to 1235, line 17. And the notes from which the note was prepared were not preserved. Mr. Charters couldn't remember whether he approved the note based on memory or with reference to the notes taker's notes. And you see that at page 1235, line 12 to 1236, line 9. And so in the circumstances, you don't have witnesses coming along and saying, well, I have got a full recollection of what happened at the meeting. What you have is witnesses who are coming along and saying, well, actually, I can't remember. I get my information about that meeting from the note itself. And indeed, in the case of Mr. Byers, saying that he was drawing inferences. And so our submission, the judge was right to take the oral view that the oral evidence didn't add anything to the note or to cure its inherent defects. Because the liquidators were only testifying about the note. They weren't giving evidence other than the note. And so that's why the only evidence remains the note. Lord, I've been given a couple of references by my learned junior. If we go to Eddie's cross-examination at page 1517, at line 16, and he says, well, I don't want to repeat it what I've said. I just think, don't you think it really is strange? Liquidators jumps to the repayment without asking details how this loan arranged, negotiate. This is just common sense. They asked about this loan for the whole process. And then 1520, lines 6 to 24. Please refer me to where Zanato is mentioned or referred to in this paragraph. It's referred to in the immediately preceding paragraph in the context of loans to the company PFF. You then say Ms. Chen tried to pay back as much of the loans made to the company as possible because she's reliant on her reputation. Now you give an example in the next sentence by reference to Harwich gain and rich concept. But the plain context of that paragraph is in relation to the conversation about Zanato loan. My lord, I don't agree to this because A, in this paragraph, Zanato is not mentioned here, and B, the paragraph before that I have put it into very clear was the answer to the questions about how the Zanato loan. That question was done, and we start another issue here. This is the verbatim meeting notes and missing a lot of context here. So I think that that's what he said. Let me check his witness statements as well, please. Just having his witness statements checked as well, that appears to be what he said in cross-examination. Can I also say that even given the liquidator's confirmation, the liquidator's reliance on the note is also misplaced for the reason given by the judge in the trial judgment at paragraph 23. Attempts by the liquidators to extract meaning which suited their case from ambiguous or non-committal responses by Mr. Chen demonstrated only the folly of treating this material as having any probative value. Now, we say the judge was right to find the responses as recorded in the note were ambiguous or non-committal. And if one goes to page 2223 of the bundle, we see there that in paragraph 78, the liquidators set out the what they rely on from the note at 754. And if you look at that second paragraph, we see that the Zanato payment queried. EC advised didn't know any further details, anything in relation to this payment, and this funding was arranged by PSG. And so you have Eddie saying, well, this refers to the payment, not the repayment. I'm sorry, I think it's in paragraph 9 of his fourth witness statement at page 1031. And so it isn't clear. It is subject to possible differing interpretations. And the third paragraph, EC advised that Diana tried to pay back as much of the loans made to the company as possible because she relied on her reputation. Again, it doesn't refer to the Zanato loans, but loans generally. And so there's nothing in the note which confirms the liquidator's case that Ms. Chen caused and or procured the particular Zanato repayments. And the judge was entitled to draw the conclusion that it was without probative value. And so what we said...
Well, I'm sorry to interrupt, but just taking that last extract, Eddie advised that Diana tried to pay back as much of the loan to the company as possible. How does that accord with the suggestion that she didn't know about the repayment to Zanato?
Well, my lord, it doesn't specifically refer to any particular loan. It doesn't refer to the Zanato loans as such. And so what's being tried to be, the liquidators are trying to rely on this to say, well, this is evidence that she caused and or procured the repayment of the Zanato loan. And there's two things it doesn't do. One is it doesn't actually say that she had any active role or any passive role in those repayments to Zanato. And it simply says she tried to pay back. Well, that could have been simply by borrowing. We know that she borrowed from Harwich Gain and Rich Concept. It could be referring to that. It's not necessarily in any way linked to the loans, to the Zanato loan. And so,
even though she was in the business of trying to pay back as much of the loans made to the company as possible, by sheer happenstance, she wasn't aware that Zanato was being repaid.
Yes, my lord. She was trying to pay back the loans. She raised loans so that she could discharge the obligations of PFF. That's how she was trying to discharge loans. But Eddie's evidence is, and it's not contradicted by this by these sentences in the note. As I said before, his evidence was that he found that there was some extra cash in the PFF accounts, and he then, particularly because of the extreme pressure that Mr. Song and his employees were putting on the employees of PSG, he decided that that cash should be used to repay Zanato. He went to Mr. Gann, got Mr. Gann's approval, and it was then, the funds were electronically transferred. So his evidence was that he had she had no involvement in that process. So that is why there's nothing there which in any way suggests that she was involved in the process. But the point is that you have a situation where the assessment, evaluation of the evidence was something which was for the trial judge. And there are two key areas here in respect of which the trial judge was entitled to reach conclusions. One was whether the note was reliable. And for the reasons that he took, that he explained, he regarded it as not reliable. And he sat there and heard the evidence, oral evidence and submissions, and he decided it was not reliable for the reasons he gave. These various statements which are in the note, they do not of themselves demonstrate either that Eddie's evidence in relation to that was incorrect or that Miss Chen caused and or procured the repayment. They are not unambiguous. If he said Miss Chen caused and or procured the repayment of the Zonato loan, then there would be no ambiguity. But given that these statements are capable of different interpretations, it was up to the judge, on the basis of the evidence he heard, to decide whether he believed what Eddie had said, his account of how the Zonato loans came to be repaid, or whether he accepted the liquidator's statements in this respect. Well, it's possibly taken a little out of context in terms of timing, but this does actually raise something that I was going to come to, but if I may, I'll deal with it now. And it's the question of whether or not, given that these are findings of fact by the trial judge that the Court of Appeal did not interfere with, whether this is an occasion when the board, the committee, should be interfering at all, because as is recognised, the Devi and Roy practice, that the court doesn't interfere with concurrent kinds of primary fact, except in very unusual circumstances. And the cases have consistently set the bar for the departure from the settled practice as a very high standard. And draw attention to Al-Sadiq in paragraph 44 at page 2364, referring to the very limited special category which justifies a departure from that practice, which is quoted in Dean and Bin at page 2524. It's also expressed in TLM and Bidazi at paragraph 5, page 3051, the special circumstances justifying a departure from the practice. And Bank of Ecuador, paragraph 4 at page 2420, with very limited circumstances. And we submit on the basis of Al-Sadiq at paragraph 44, page 2364, it isn't just a question of the scales being loaded against the appellant. If the practice applies, then there's no interference at all. And the burden is on the appellant to establish that the case falls within the very limited special category justifying departure from the practice. And to justify a departure from the practice here, the appellants must appoint to circumstances of similar seriousness. But there's nothing complex or exceptional about this case. The trial judge heard the evidence. By and large, he accepted Ms. Chen's evidence. He accepted Eddie's evidence on the basic facts which we identify in paragraph 4 of our case concerning her directorship and whether she caused or procured the payments. And he specifically found that she didn't cause or procure the payments, the Zanato repayments. The Court of Appeal then carefully listens to the appellant's criticisms, examines the evidence, and comes to the same conclusions. And you see that from paragraph 74 of the judgment at page 60.
Well, quite, but I take it that you accept that these factual findings are interlinked, if not indeed interdependent. And it seems to me at this present, you haven't reached this stage of your argument yet, but the judge's finding that she ceased to be a director in August 2009 is fairly pivotal to his finding that she knew nothing about the repayment of the loans to Zanato. If you remove that finding from the equation, just for the sake of the discussion, a rather more focused light shines on his finding that she knew nothing at all about the repayment of the loans, particularly in light of this note at paragraph 78 of page 2223. In any event, you're going to come, I assume, to the question of the judge's finding in relation to the cessation of directorship. That does seem to me to be a pretty important part of the case that you have to meet.
Well, my lord, of course I'm going to come to it. What I would say is this, that even if she were a director, and even if she had fiduciary duties, if she didn't cause and or procure the payment, then she wouldn't have acted in breach of those fiduciary duties. And that's one of the reasons why I was dealing with ground 3 before coming to ground 1 and 2, because in my submission, if the judge is right that she did not cause and or procure the payment, then the fact that she's a director, or the fact she has fiduciary duties or not, is not relevant.
Yes, so the question of whether she caused or procured the payment, the repayment of the loans, must surely be fairly heavily dependent on whether or not she was a director,
With respect,
especially if she was the sole director.
With respect, no, my lord, if she set up a system and she had trusted that system to work, and she did not say, give specific directions for the payment of specific sums of money, then she did not cause or procure. As I said before, that's the way the case is pleaded. It's not pleaded on any other basis. And so, Lord has a question.
Yes, Lord Liggett.
What my lord, to follow up what my lord has said, if it were to be the case that the judge was wrong to find that she ceased to be a director because there was simply no basis for that, that therefore means he approached the question of her involvement on a fundamentally wrong factual basis. And it's bound to be relevant, isn't it, when assessing the likelihood that she did or didn't procure or instruct the payment, as to whether you've previously reached the conclusion that she was the director or whether it's Mr. Gann at that point, for example. I mean, once you accept it's her, then the whole thing may unravel.
Well, with respect, my lord, I'm not able to agree with that for this reason. That your lordship's absolutely right in terms of the legal framework. But the question of causing and of procuring is a pure question of fact. It has nothing to do with whether she's a director or not. Let's assume that the judge was right to accept Eddie's version of events, which, in a very brief summary, is Eddie discovers money in the account. Eddie realizes that Zanato are putting a lot of pressure on. Eddie decides that the way to get the pressure off is to pay back Zanato. Eddie goes to Mr. Gann And he then says, can we pay back? And Mr. Gann says yes, and there's a repayment. That's the encapsulation of the factual basis on which the payments are made. Now, it makes no difference to whether or not Miss Chen caused and or procured that she may or may not have been a director in that process. If she's not a director, then the process operates completely independently of her. But if she is a director, she still doesn't have any involvement in that process. She's doing whatever she's doing, but she doesn't know that what's going on. And so if one simply regards it as a question of fact, whether or not she's simultaneously under a duty is neither here nor there on the question of fact. I've already made my submissions on no and not object, so I'm not going to repeat those. And in my submission, the finding as to whether or not she was a director, which I am going to come back to, of course, when I deal with grounds 1 and 2, that simply isn't something which in our submission impacts on the factual issue of who caused and or procured the payment. Well, I can't really take it any further than that.
Yes, but I think perhaps, given that you have a limited time, you might want to move to grounds 1 and 2.
Well, Lord, I think I've still got about 55 minutes. Have I got?
No, you've 27 minutes.
Sorry, Lord, how many?
57.
57.
27.
27.
Sorry, Lord, we're coming through very clearly. Well, can I just then say, so far as the Court of Appeal judgment is concerned, what is relied on is delay, and we say delay isn't enough. There has to be something which shows that there was not a proper judicial process, and it's not enough, as the appellants say, that there should be some mistakes which are possibly or probably relevant, and they rely on Cobham and Frett. But the point is that Cobham and Frett doesn't support the appellant's case, because Cobham and Frett is a case about delay in the trial judgment. We're talking about a delay in the Court of Appeal judgment. And there is no citation or discussion of authorities such as Devi and Roy in Cobham and Frett, which shows that the court, that the board was trying to amend the practice in Cobham and Frett. And the appellant's suggested approach puts the cart before the horse and says, in effect, the court can intervene if there's a delay plus errors of which they complain. But that simply is wrong in our submission, because it would permit them to involve the committee in investigating concurrent findings in order to decide whether or not it should investigate concurrent findings. In our submission, that the correct approach is that which was taken in Al-Sadiq, which is the committee has to scrutinise the judgments of the Court of Appeal to say whether they can properly be said to fall within the exceptional category which fail to constitute judicial procedure at all. And we say that that is simply not something which can be done in this case, because when you look at the Court of Appeal judgment, it's set out in no less than 31 paragraphs, the appellant's submissions. And in each case, it considered them, it discussed the legal principles, it discussed the judge's findings, and so there was a perfectly legitimate and proper judicial process. So we would submit that actually, in any event, this is not a case where the board, the committee should intervene. Now,
surely the point about the decision in Sadiq is that where there's delay, the court should scrutinise more carefully to see if there are errors which fall within the Devi and Roy principle. One gives it a much closer scrutiny than one would if there had been a normal time lag.
Milady, yes, that's right. But what we submit in relation to that is that it's the Court of Appeal judgment, which is the one which is to be scrutinised rather than the trial judgment, because the trial judgment has already been scrutinised once by the Court of Appeal. So this is not an appeal from the trial judge. This is an appeal from the Court of Appeal.
Even if you limit it to the Court of Appeal, there is still a scrutiny to be effected to consider whether the Court of Appeal failed to pick up errors in the judge.
Yes, my lady, I totally accept that. So I'm sorry, I was just checking to see whether there's anything else I wanted to say on ground 3, but there isn't. Come now to this question of de jure director of PFF, and if I could take the committee, please, to the judge's judgment at page 25 of the bundle. This is important because it seems to be the basis on which the appellants seek to persuade the committee to intervene in this case. But what we say is clear when one looks at the learned judge's judgment. There is no finding that the Miss Chen resigned in August. What you have is paragraph 18. You have the judge recording that Ms. Chen wrote a letter of resignation from her directorship of PFF the 29th of May 2009. There's evidence which I shall consider in a moment. She did not cease, or at any rate was treated as not having ceased to be a de jure director of PFF on that date. I've no doubt, however, there was nothing contrived about Ms. Chen's resignation. I'm satisfied she had originally intended to have effect from 29th of May 2009. So we see there that the judge is accepting that the intention to resign was a genuine one, and that the letter of resignation was 29th of May 2009. And towards the end of that paragraph, he says that the unpleaded allegation resignation was backdated is not made out. And he says it's irrelevant given its common ground that she effectively resigned long before repayments to Senator in contemplation. Now, we accept that that reference to common ground is incorrect, but what we say is, well, the learned judge found that she had indeed resigned long before the repayments to Senator were in contemplation. So, albeit it was an error, it was not an error that actually went anywhere. And then he refers to the other resignation at the same time. And he then goes on to talk about the hopeless confusion. And then he, paragraph 20, he says there's clear evidence that PFF staff to continue to behave as if Ms. Chen remained a director of PFF until well after 29th of May. Particularly in July 2009, they sought her signature to board resolutions of PFF authorising Mr. Chen to execute settlement agreements with FFA creditors. 14th July, she gave advice at the and refers to the email of the 20th of July and then the note of the 29th of July. And then he says, refers to the gap until mid-November, and he deals with this question of the absence of documentation on Eddie's laptop. Now, again there, the judge accepted Eddie's explanation about what had happened in relation to the laptop. And he was perfectly entitled to do that. Eddie told him, gave his evidence in relation to the laptop, and he talked about the technical difficulties. He talked about the system where all emails self-deleted after a few days. And I can tell the court that I had a recent case where a similar program had been used, where there was self-deletion after a few days. And he rejects specifically the suggestion that the absence of documentation is sinister or enables the liquidators to plug their evidentiary gap. And he then refers to the paragraph 22, sole signing rights issue, 23, the note. And in 24, he then deals with the other evidence of involvement in discussions, in liquidation discussions, before coming on to his conclusion in paragraph 25, which is that for whatever reason, she did in fact remain a de jure director of PFF, capable of signing board resolutions till around the beginning of August 2009. No evidence she was involved in the affairs of PFF at any level or at all between then and the time that it came to put PFF into insolvency procedure in November December 2009. So what he's found is that one is that the resignation in May was genuine, and that for whatever reason she remained a de jure director until August 2009. So there's no question of him saying, well, she resigned in August. The judge is talking here, paragraph 25, of when that resignation in fact took effect.
Lord Leggett has a question. I think you need to unmute.
Sorry. On the judge's conclusions, how do you say that Tran ceased as a matter of law to be a director at the beginning of August? I mean, what is the legal analysis of that ceasing to be a director then?
Well, my Lord, what one would say is this, that if you give notice to end your directorship and you then can, on a certain date, you then continue to sign board resolutions or whatever, and then stop, you can infer.
I can't hear you, Mr. Joffe.
I'm so sorry. If you, sorry, my Lord, you disappeared and came back. Are you still online?
Yes, I am.
Very much obliged. If you put in a letter of resignation with a specific date, but then the company then sends you board resolutions to sign, and you then resign, then you sign them subsequent to that date, but then subsequently you cease to act as director, then clearly you and the company have agreed to extend that directorship in an informal fashion until such time as you cease acting completely. Now, there's no reason why, since the question of resignation is something which is as between a company and a director, why the company and the director shouldn't do that.
But that wasn't her case.
Well, it wasn't her case, milady, that she continued to be director until August. That was something which the learned judge found. And my Lord Leggett asked me a question of how you justify that in legal terms. And that's the question that I was asking. But you're quite right, it wasn't her case. Her case was, there was this letter in May, which effected a resignation. And the judge then turned around and said, well, it didn't take effect in May, it took effect in August. Now,
I'm sorry to interrupt, but if you look at paragraph 18, he said, I'm satisfied that she had originally intended to have effect as from the 29th of May 2009. Implies clearly that that intention was changed.
Well, my lord, in the light of his finding that she continued to be a director until August, it would necessarily have to change, because you couldn't you couldn't otherwise explain it. But my lord, I should say that this was examined in great detail. The underlying evidence was examined in great detail at the trial, and indeed there were extensive submissions on it in the Court of Appeal. My learned friend adverted this morning to various emails that were sent to Ms. Chen. That was covered in the evidence. It was covered in the submissions. I think my learned friend took the committee to where I had made submissions on these emails at the trial. Many of them were predated the August date, and others related to Ms. Chen in her capacity as director of PSG rather than director of PFF. But the judge had all of those emails, and I should also say that he also heard evidence on all the Tricor matters. That was not raised in the witness statements, it was only raised in cross-examination with Ms. Chen. So he had all that evidence before him. He also had before him received submissions on the emails in December, and there's a footnote on one of those, which I want to just raise in a moment. So the learned judge had the full purview of the evidence before him. He had on the letter of resignation, he had all of the emails in July, and he had the Tricor material before him. He had the December material before him. So he'd
forgotten a material point. The reason that he reaches that finding in sentence 1 of paragraph 25 is the reason given in the second sentence, namely there was no evidence of involvement in the affairs of PFF at any level between then and the time of the insolvency. But he's forgetting one vital factor. She remained a signatory on the bank account. She didn't come off. She therefore had an involvement.
Well, my lady, as a matter of fact, you don't need to be a director in order to be a signatory. Now, it would have been up to the company to arrange for her to be taken off as a signatory and to pass a resolution appointing somebody else. And so the mere fact that she remained to be a signatory, in my submission, was not a material factor. And it didn't show that she had any involvement. In fact, the evidence was exactly to the opposite, that she had no involvement. May I just...
Yes, Lord Leggett.
But you've referred to all the evidence the judge had, but what I'm still struggling to see is that he had any evidence of anything that happened at the beginning of August that was capable of changing her legal status so that she was no longer capable of signing board resolutions, use these words in paragraph 25. I mean, there wasn't anything that changed her legal status then, was there? Unless something happened in her head, and that was sufficient.
Well, my lord, until the beginning of August, you see various emails which either refer to her or ask for her advice. You don't, after that, there's nothing from there all the way through to December.
You don't stop becoming a director because nobody sends you emails anymore. That doesn't remove you from the board.
Well, my lord, but she had already resigned. There had been, as it were, an informal continuation because she continued to be involved in the company, as the judge found. That was the basis on which the extension of the directorship was continued. Once that involvement no longer existed, then there was no basis on which she continued to be a director. She was only a director because of the involvement. Once the involvement goes, that was the end of the directorship. Comes back to what I was saying before, that if you asked me to analyse it, and the way I analysed it was, well, there was an informal extension whilst they were still asking her to do things. And once that came to an end, that was the end of her directorship.
Yes, well, you've got very limited time left, Mr. Joffe, so you better move on.
Well, my lord, can I just give you that there's a reference to litigation with Claveness in the December email that you were taken to this morning. What we would say is that that email was written at a time when insolvency was about to come about, and so there's good reason to adjourn the hearing. But if you look at page 1530 to 1531, you'll see that Eddie says that anything to do with Claveness was to do with Miss Chen's role as ultimate owner of PSG. Look, so far as grounds 1 and 2 are concerned, most of what we want to say on it, other than what I've already said, essentially is contained in our written case. And I do ask you to look at that, what we say on grounds 1 and 2. The matter that I would like to deal with in the last few minutes that I have is this question of whether or not it is sufficient to impose fiduciary duties that Ms. Chen had signatory rights. And in relation to that, what we would say is simply this, that imposition of fiduciary duties is something which is always highly fact sensitive. And you can well see that in certain circumstances, that if you are a signatory over somebody else's account, or if you're a trustee who has signatory rights over somebody's, over the beneficiary's monies, that is sufficient to impose fiduciary duties. But we're not dealing with that sort of a case here, because what we've got here is we've got a system which is set up by Ms. Chen, no doubt when she was a director, and it's set up in a way so to operate the company's bank accounts for the benefit of the company's trading in what were clearly sort of very fast-moving and intense commercial circumstances. Now, if one says, well, she had fiduciary duties as a director, though for the reasons that we've given today and in our written case, she wasn't, then, well, you have the full suite of directors' fiduciary duties in any event. But so far as the bank account is concerned, question is whether or not the system which is put in place is sufficient. And it impacts in two ways. One is it's sufficient to comply with fiduciary duties if you are a director, and it's sufficient if what's done to, as it were, provide circumstances where no fiduciary duty arises in the first place in the other. Now, if she was a director, by setting up the scheme that she did in relation to directors' fiduciary duties, that was, we say, sufficient to comply with fiduciary duties, because the system required the approval of a director. While she was a director, she gave approval, and afterwards, Mr. Gang gave approval from and that we see that from Eddie's evidence. When one comes on then to the question of whether or not there are fiduciary duties imposed simply on the basis of continuing to have the signing rights, well, first of all, the system which was implemented was such that there was no question of any personal misuse being made of the monies. What happened was, as I said before, Eddie would make suggestions, there'd be approval, and then the payment would be made for PLF's proper purposes. And there is no factor, if she was not a director, no factor other than that, which would lead to justification for imposing fiduciary duties of any broad spectrum. If anything, there was only a fiduciary duty to ensure that the money was not applied for personal uses rather than the uses of the company. In the course of my submissions, I've referred on a number of occasions to Eddie's evidence. As your lordships will know, the learned judge accepted Eddie's evidence, having heard him being cross-examined over a lengthy period of time. It is important in relation to this to appreciate that Eddie had no motivation to lie. Eddie no longer worked for Miss Chen. He wasn't in any way interested in the proceedings. He wasn't a respondent, and so had no motivation whatsoever not to tell the truth to the learned judge. And when we deal with Eddie's credibility in our written case, we do make the point that so far as Eddie was concerned, there's no motive for him not to tell the truth, and the learned judge was perfectly entitled to find that that he was telling the truth. I see that I've exhausted my time. Unless there's any questions that I can answer.
Yes, Lord Kitchen.
Could you help me with this? Eddie was emphatic that he had to and obtained approval for payments after the 29th of May from PFF's de jure director. Now, as I understand it, the judge was not very attracted by the notion that Mr. Gan or Mr. Song replaced Ms. Chen as director, and certainly not as the director whose approval Eddie sought. So if there is no finding by the judge that either Mr. Gan or Mr. Song became a director, is that a strong indication that Eddie Chen must have been getting his approval from Ms. Chen?
I think that's a point actually which we do cover in the written case, but I think that indeed, I think yeah, it's page 2249 of our written case, and so I may have the reference wrong, but the point is that 2250. Thank you. Eddie's evidence was that he had approval for the repayments from the director, who he thought was Mr. Gan, and the point made against us was, well, if Mr. Gann wasn't properly announced, then the director must have been Ms. Chen. And so what we were discussing, the Court of Appeal addressed that, and they said, well, was it possible for Eddie to have the foresight that it might be suggested subsequently in 2015, Mr. Gann wasn't properly appointed. So what Eddie was doing was he was getting the approval from Mr. Gann because he thought that Mr. Gann was the director. It wasn't a case that he was saying, oh, I got it from the director, and that he, because the director on the judge's findings wasn't Mr. Gann, therefore it wasn't Mr. Gann.
Yes, Lord Kitchen.
May I just ask one other question? Would you accept that by November 2008, that there was a duty on any de facto or de jure director to consider the interests of creditors in deciding whether or not to make a payment?
Lord, if they were aware that the company was insolvent or about to become insolvent, that's right, yes.
Right. Thank you very much indeed, Mr. Joffrey. Does Ms. Cann wish to follow?
No, she doesn't, thank you.
Perhaps I can express my apology for having wrongly assumed that it was Mr. Cann to her. Now, Mr. Smith.
Can you?
No, we can't hear you at the moment, I'm afraid.
Now?
Yes, we can hear you now, yes.
Thank you. Right, I think I've got 27 minutes, so I'm going to go fairly quickly if I may. Just on the last question that my Lord Kitchen asked, I think he meant 2009, not 2008. So at the risk of causing Lord Briggs dismay, if not wrath, in answer to his two questions, I've had a look at Scandinaviska. I confess I haven't read it word for word.
It's never wrathful.
And that I think, with respect, my lord, was a different situation in the sense that there was no statutory remedy for unfair preference, so you had to fall back on restitutionary principles.
I think Lord Briggs may have something to say about that.
Yeah, I was simply going to acknowledge that, Mr. Smith, I also spent part of my sandwich time reminding myself of the detail. It was a common law case where the statute made no provision. But I think that probably the deeper question is whether that having been the position for over a century of common law, the way the statute framed really makes any difference.
Yes, well, neither of us has gone into that deeper question. If you want us to, we're going to have to do it in writing later.
No, thank you.
Cancelled, we haven't been able to find anything on the writing of cancelled on document 588, I'm afraid. So sorry about that. Now, I don't think I wish to add very much at all on Malone Friend's submission, in respect to Malone Friend's submissions on ground 2, where he just finished. However, my attention has been drawn to document 769, which you may find interesting, particularly in the light of Lady Arden's intervention. It's an email of the 1st of June 2010 from the Bank of America, or somebody at the Bank of America, to Grant Thornton. And they confirm that the signature mandate held on file since person listed, that's Diana, and they're listed as a director and able to sign as category A full limit. So she was on the mandate and they were told she was a director, and they don't seem to have been told she ever ceased to be a director, which in our submission supports our, as it were, alternative argument on fiduciary duty. Now, on ground 1, the de jure director point, learned friend, of course, was right to accept that the learned judge went wrong in paragraph 18 on page 25 of the bundle, when he said it was common ground that she had resigned as a de jure director before the repayments to Zanata were in contemplation. That is a very significant mistake that the learned judge made, because if he had it in his head that at some stage she resigned, it's easier to see why he thought, well, where do I put the pin between the end of July and December? But because it was common ground between the parties, but it wasn't common ground. And therefore, that possibly explains how he began to lead himself into error. Now, what we seem to have now is a new case or a new position adopted by Ms. Chen, and that is that the directorship was extended informally, or rather, I suppose the resignation was held in abeyance until August, and then somehow or other the abeyance came to an end and the resignation was implemented. There are two problems that come to mind. First of all, that's never been her case. I don't recall hearing that argument previously, certainly wasn't her evidence, and it's not borne out by her defence. In particular, see paragraph 16 on page 170. And nor did the judge make that finding. He didn't find that the letter of resignation was, as it were, held in suspension till August. He made a finding that she ceased to be a director in August because she ceased to be involved. That's clear from his judgment, and with respect, he was wrong. Could I also remind the committee of where I started, and again reiterate my apology that you don't have section 115 of the Companies Act. The Companies Law in the BVI, and we really ought to supply it, and we will do. But section 115.1 says director may resign by giving written notice of his resignation to the company, and the resignation has effect from the date the notice is received by the company, or from such later date as may be specified in the notice. There's only one date on that notice, and that's the 29th of May, not some unspecified date in August. So according to the Companies Law, it couldn't have, that letter could not have the effect. Yes,
Lord Briggs.
In the light of the judge's finding that that was a genuine letter, not backdated, why did it not take effect of ending her de jure directorship on the 29th of May, with the consequence that since there's no evidence of her being reappointed by a meeting of shareholders or by any other constitutional office, she was only de facto then, because she and the company went on treating her as if she was a director?
I think because of he could see that nothing really changed in practice at that time.
Quite often happens when somebody takes a step which has the legal consequence that they're no longer a director, but both they and the company go on treating them as if they are.
Well, he drew the inference that she had not ceased to be a de jure director.
Yes, I know.
I suppose we can also say you can draw that inference because people like the Bank of America and Holman, Fenwick and William were not told that she'd ceased to be a director, which one would have expected if she had ceased to be a director, they would be some of the first people to be told.
Of course, it's also significant that the judge said that it was her original intention to retire as a director.
And it's also
which implies, it seems to me, at first blush, and obviously one would need to reflect on this, but it implies that that intention changed.
I respectfully agree, my lord, and it's also fair to say that the judge had, well, I infer, I wasn't at the trial, but I infer he was sympathetic to what Miss Chen had just gone through in terms of being held incommunicado in China by the government to assist them with some inquiry that they were requiring her assistance with, and therefore she'd gone through a period of trauma, which he may have felt led her to write something which actually she decided that she wasn't going to see through. Anyway, he found that she did not cease to be a director at that point in time, and there's been no challenge to that finding.
Yes.
So that, with respect, stands. Think there's anything further I need to add to what I said in opening on that. Now, coming on to cause and procure. My friend said knowing and not objecting to a payment is not relevant if there is no duty, but as you pointed out, my lord, our case is there was a duty on one or other ground of grounds 1 and 2, and therefore knowing and objecting is a relevant finding. Sorry, knowing and not objecting is a relevant finding. My friend also said that, or submitted that the judge didn't find or make a finding as to when she knew. So if we look at that, the last sentence of paragraph 28 on page 29, he said, I think the probability is that she knew of and did not object to the repayment. And then he goes on immediately to say that, of course, is not the same as causing or procuring the repayment. That suggests that the time he's thinking that she knew of and did not object is a time in advance of the repayment, not after the repayment. Too late to object to the repayment once it's happened anyway. So, with respect to in that point, then my learned friend took a point about the judge's finding. He seemed to be challenging the finding that the probability is that knew of and did not object to the repayment. And my lady, Lady Arden, asked whether those points were made at the trial, and my learned friend accepted that they weren't. There was no respondent's notice, as far as I can recall, for the Court of Appeal hearing. And it's this point that the judge erred in making that finding at the end of paragraph 28, as far as I can, doesn't feature in his written case for this hearing. And the relevant passage is at pages 2253 to 2255 of the bundle, where I don't find any reference to the judge having erred in finding that she knew of and didn't object to the repayment. We say clearly prior to the repayment being made. So that's, I think, all that I was intending to say on the causing the repayment point. So far as the note is concerned, which we rely on to say that there was evidence that she procured the repayment. Of course, we have our points, which I don't think my learned friend addressed, about Eddie accepting the scope of the questions which the liquidators were asking him, and I gave the references this morning. That's 1515 and 15 to 1517 of the bundle. We do not agree, but I've made this point already, that the oral evidence supports Melissa's point that the liquidators had no independent recollection of the meeting other than the note. And the relevant passage is at 1203 to 1204 of the bundle. Now, so far as the reference to loans in the note, that's at page 754 of the bundle, loans in the plural must include the Zanato loan. As I said in opening, the Zanato loan was the only loan repaid in full. There was a repayment of part of one of the other loans. I think it was a Harwich Gain loan. Unless it's suggested that the reference to loans in the plural in the note was erroneous, then the reference must have been to the Zanato loan. And with respect, the judge wasn't entitled to find that the note was not reliable because he didn't refer to any of the evidence, written or oral, about how the note was prepared and what the recollections of the liquidators and of Mr. Byers and Mr. Charters was. And that, I think, is a complete answer to Malone Friend's point, relying on Devi and Roy and the later cases which have applied Devi and Roy or distinguished. In this case, there are examples of the judge not only having erred, as a matter of fact, and we would say law, but also not having taken proper advantage of seeing and hearing the witnesses, especially as regards the note. That then, I think, brings me to the submissions Malone and Friend made on section 249 and his first point, which I think he made later again, was the section is restitutionary, not compensatory. There is nothing in the section that says it can only be applied when somebody has obtained a benefit in monetary terms. What subsection 1b says on page 2302 of the bundle is that in respect of an unfair preference or an undervalued transaction, the court may make such order as it considers fit for restoring the position to what it would have been. Now, that does not mean, as submitted this morning, turning the clock back and putting everybody back in the same position. It means restoring the position for the company to what it would have been if the company had not entered into the transaction. And although the judge in Johnson and Arden said that you have to look at the possibility of all parties having their position restored. That's page 2797, paragraph 92 of her judgment. With respect, she was wrong. She says it's not limited to restoring the position of the company, but to putting all parties back into the position they would have been in had the transaction not been entered into or the preference given. But when you're ordering one party to repay or to make a payment, particularly if it's a third party, then it makes no sense to look at the position of the third party. And that submission appears to be borne out by the citations of my submissions, appears to be borne out by the citations from the authorities in paragraph 104 and paragraph 105 of this judgment. I'm afraid I don't believe we have these authorities in the court's bundle, but in 104 there's a reference to a judgment of Mr. Justice Hart in Lord and Sinai Securities, where his lordship said it is at least arguable that the court's primary and possibly only concern under the undervalue section, transaction at an undervalue position, which is very similar, is the restoration of the company's position. The position of the counterparty needs to be considered by the court as a general matter of discretion, but the court is not obliged to ensure that his position is restored in every particular to the status quo ante the transaction. There will be many cases where that is simply impossible, and in the case of a third party, that's one such case. And similarly, in paragraph 105, with a citation from the Court of Appeal, judgment of Lord Justice Norris to similar effect. So we do say, with respect, that the two deputy judges in the Oxford Pharmaceuticals case and Johnson and Arden have erred when they impose the restrictions on the general discretion, which is conferred by section, or the equivalent of section 249 in England. So far as the points on the pleading, which the learned friend took in this context, what he, I think, was submitting that the pleading refers to Diana Chen's motive in making the payment, not that she referred a benefit. But in the context of this case, it's not difficult to infer that that benefit was achieved. And I say that because the evidence was that Mr. Song was a very voluble creditor and put a lot of pressure on the company to repay, even though it was an early, premature repayment. And there's no evidence that pressure continued in any shape or form after Zanata was repaid. We don't need to establish that there was no prospect of recovery from Zanata, but you have the evidence as to why Zanata was not pursued, which Mr. Byers gave. Now that's either it's evidence which it's a view which he genuinely held, and it can't be suggested that he didn't, that pursuing Zanata wasn't worth powder and shot. But we don't need to establish that it is that there's an inability to pursue anybody else before being able to ask the court to exercise its discretion to restore the position against somebody in respect of somebody who was, we say, involved in making the preferential payment. And I think if I say any more, I'll be repeating what I said in opening. So, at the risk of
try to encourage
minutes,
counsel not to do that.
I'm not going to take my full allocation in that case.
Well, thank you very much indeed, Mr. Smith. We're very grateful to you and to Mr. Joffe for your oral presentations, and of course to those who have assisted you in the preparation of written submissions. The board will take time to consider what advice to humbly tender to Her Majesty, and the court is now adjourned.
Thank you very much.
Thank you very much.